found in one case that a firm continued to benefit from another SBA program even though it had misrepresented its HUBZone eligibility and had been decertified. When GAO did further investigation on this company, it was discovered that the firm had also misrepresented its status in the 8A program as well. So my question is, how could this happen? And when SBA finds that a firm is ineligible for one program, do they cross-check it with another? What's the process?
It doesn't appear they did in this particular case until perhaps they got our 8A report and they found it was with the same firm that we had found in the HUBZone program. So you have to ask the administrator, but I don't think in that case they did. That is a good practice. We have definitely suggested that to them in our corrective action briefings, not just 8A, but all their other programs. Because, again, if people are inclined to commit fraud, they're not going to just do it in one area. We found that with tax cheats and a lot of other types of places. You don't just do it once. You typically are a repeat offender.
Administrator Mills, do you want to comment on that?
In fact, I don't know if it was a specific recommendation that you have, but it's something that's has been discussed, and we're looking at the computer compatibility because it's quite obvious that you'd want to do this.
How about the sort of the opposite scenario? Hypothetically, when one firm that does business with the SBA qualifies legitimately in one program but misrepresents itself in another program, what are the consequences to that? What's being done to prevent that? What happens in the program that they're legitimately qualifying for?
So far, we haven't seen anything as a consequence. I don't know if going forward they're looking at doing that.
I think that's a good question, and one of the issues is coming down to the facts, which is, in what way did they get disqualified? Is it a foot fault or is it a fraud?
Right. And for Administrator Mills, as you know, in the 2008 report, GAO recommended that SBA formalize a specific time frame for decertifying HUBZones. As indicated in the previous reports, SBA had an informal time frame for decertification of 60 days. I was wondering, has a formal time frame been implemented yet, and if so, what is that time frame?
I'm happy to get back to you.
Okay, thank you. Do you know what's being done at the SBA to ensure that those contractors that are in the process of being decertified are not receiving HUBZone contracts while that's taking place? While they're in the process of decertification, that they're not still qualifying for HUBZone contracts?
Our process is that we turn them over for investigation. There is a fact-finding, and as we know that sometimes we have found that, in fact, they were put up for decertification, but they are eligible. Right. And so we do presume that they're innocent until we find the facts, and then we go after them.
Right. And my final question for Administrator Mills. GAO has found that 5 of the firms that had been decertified were still continuing to claim on their websites that they were HUBZone certified. What does the SBA do to prevent this type of misrepresentation?
Well, we would not necessarily know what's on their website, but we do believe that in some areas, for instance, service-disabled veterans, we are now requiring them to take themselves off the Federal Register. So and if they don't take themselves off, we take them off.
Okay. So Mr. Kurtz?
We'd be happy to make sure. If they don't know who those ones are that still have hubs up the decertified, we will let you know that. So you can maybe send them a little email message or something.
Be happy to do that.
So how does that work? Is there someone that searches to make sure that those people that have been decertified have not continued to claim, or is it something that would have to be brought to your attention?
That's something we did as part of our investigation. We wanted to see, once they were decertified, they still held themselves out as being HUBZone firms.
Is that something that will be done going forward?
We wouldn't do that. That would be something SBA could consider, certainly.
Okay. Well, maybe give that some consideration. Thank you both for your testimony.